What if I told you a law once existed in the United States that was so powerful, so quietly dangerous, that when it disappeared, almost no one noticed? No headlines, no debates, no public outrage. It was just gone. But here's the unsettling part. Some people still believe it never truly went away. Because sometimes laws don't just get repealed, sometimes they get erased. Welcome to AM Story Archives.
Some stories were never meant to be found. Some truths were buried for a reason.
The story begins in the late 1970s, at a time when America was still recovering from a series of political scandals, intelligence overreach, and public distrust. Behind closed doors, lawmakers were trying to strike a delicate balance between national security and personal freedom. Buried deep within a larger legislative package, hundreds of pages long, was a small, almost invisible provision. It didn't have a catchy name. It wasn't debated on television. In fact, most members of Congress barely mentioned it. But those who read it carefully understood exactly what it could do. The law gave federal agencies the authority to conduct preventive monitoring on individuals who were not suspected of any crime. Not criminals, not suspects, just people. At first, it sounded harmless. The wording was vague, wrapped in bureaucratic language about emerging threats and national stability. Officials argued it was necessary. After all, waiting for a crime to happen could be too late. But here's where things started to get strange. Unlike other surveillance laws, this one didn't require a warrant in the traditional sense. Instead, it allowed internal approval, meaning agencies could authorize surveillance themselves under certain conditions. No judge, no courtroom, no outside oversight, and almost no one outside the system knew it existed. For years, the law sat quietly in the background. It wasn't widely used, at least not officially. There were no press releases, no public reports, no statistics released to the media. But in rare internal memos, documents that would only surface decades later, there were hints. References to early intervention monitoring, lists of individuals flagged not for what they had done, but for what they might do. And that's when the ethical lines began to blur. Imagine being watched, not because you broke the law, but because someone believed you could. No warning, no charges, no way to know. Through the early 1980s, a small group of analysts inside federal agencies began raising concerns. They noticed patterns. Certain types of people were being flagged more often than others. Writers, activists, academics, people who challenged ideas, people who asked questions. Internally, some called it predictive governance. Others used a more chilling phrase, pre-crime screening. But officially, the law remained invisible. Then came the turning point. In 1986, a mid-level analyst, someone's name has never been publicly confirmed, allegedly stumbled upon a series of files that didn't make sense. Thousands of entries, detailed behavioral profiles, communication logs, travel records, and in many cases, no evidence of wrongdoing. Just speculation, just predictions. The analyst reportedly tried to raise the issue through internal channels. At first, it was ignored, then quietly dismissed. Eventually, they were reassigned, but not before copying a small portion of the data. What happened next is where the story becomes even more unsettling. The information never made it to the press. It never reached the public. Instead, something else happened. Within a year, the law was quietly amended, then revised again, and then removed entirely. No announcement, no explanation, no public record of debate. It was as if the provision had never existed. But laws don't just vanish without a trace, or do they? Decades later, researchers digging through archived legislative documents began noticing inconsistencies, references to sections that no longer appeared in official records, page numbers that skipped, citations pointing to language that couldn't be found. At first, it seemed like clerical errors, but the deeper they looked, the more patterns emerged. Something had been removed. Not just repealed, not just rewritten, removed. And here's the strange part. When historians tried to track down earlier versions of the legislation, many of them were missing. Physical copies gone. Microfilm archives incomplete. Digital records altered or overwritten. It was as if someone had gone back and cleaned it up, carefully, precisely. And that raises a question no one has been able to answer. Why? Why remove a law so quietly that almost no one would ever know it existed? Some believe it was an attempt to correct a mistake, a law that crossed a line, one that threatened civil liberties in a way lawmakers hadn't fully understood. Others think it was something else entirely. Because around the same time the law disappeared, reports of certain types of surveillance didn't. In fact, they increased. Different programs, different names, but similar methods. Monitoring without clear cause, tracking without transparency, and always just beneath the surface. Former insiders, speaking anonymously years later, hinted at a possibility that's hard to prove, but even harder to ignore. What if the law wasn't removed because it was wrong, but because it was too visible? Think about it. A written law can be challenged, debated, taken to court, but something unofficial, something that operates without a clear legal framework, is much harder to confront, because technically it doesn't exist. There's nothing to point to, nothing to fight against, just shadows. One retired official reportedly described it this way: "It's easier to control something when people don't know where it begins or if it even exists at all." By the early 1990s, the conversation had shifted. New laws were introduced, focusing on digital surveillance, communications monitoring, and emerging technologies. Public attention moved forward, but the past stayed buried, or at least that's how it seemed. In recent years, as declassified documents slowly emerge and investigative journalists revisit old records, fragments of the story have started to resurface. Not enough to prove everything, but enough to raise questions. Strange gaps in documentation, unexplained references in internal communications, and occasional mentions of programs that don't appear in any official legislation. It's like looking at a puzzle with missing pieces and realizing those pieces might have been removed on purpose. Today, no government agency officially acknowledges the existence of that original provision. There's no record of its full text, no public explanation of its removal, and no clear answer as to how it was used while it was active. But the idea behind it, the concept of monitoring potential threats before they act, hasn't disappeared. In fact, it's more relevant now than ever. With advanced technology, data tracking, and predictive algorithms, the line between safety and surveillance continues to blur. And that brings us back to the question at the heart of this story. Was this law removed to protect the public or to protect something else? Because if something that powerful could exist once, hidden in plain sight, and then be erased without a trace, what else might still be out there, unseen, unrecorded, unnoticed, waiting in the background, just like that law once did?